and if members can do the needful with any electronic devices. There's no apologies, and today we're dealing with the oral evidence in relation to the on-the-run administrative scheme, which at our meeting on the 6th of March we discussed the on-the-run scheme and letters, and the committee agreed to request the attendance of a range of individuals to discuss the matter. So if someone wants to bring in Nick Perry. Nick Perry is one of the individuals that's been requested to attend the committee, and he will join us hopefully imminently. Okay, can I welcome Nick Perry, Permanent Secretary from the Department of Justice, to the meeting. Just to advise members and Mr Perry, this will be recorded by Hansard and then it will be published in due course. I'm going to invite Mr Perry to make some opening remarks, and then we'll just move straight into questions which will hopefully help enlighten members around this particular scheme. So Mr Perry, I'll hand over to you at this point.
All right, Chair, thank you very much. I will, if I may, say just a few words by way of introduction. Your letter inviting me here today referred to a lack of clarity relating to the issue of OTRs, and I'm happy to try to clarify matters as they relate to the work of the Department of Justice since its creation in April 2010. Developments before that, and any operation of a scheme relating to OTRs after devolution, are of course a matter for the Secretary of State and the Northern Ireland Office. The Justice Minister has already addressed on a number of occasions one area of confusion which has arisen in parts of the media, but I mention it again here because it's of fundamental importance. Neither the Department of Justice nor any of its staff have had any involvement with the operation of any scheme relating to OTRs since the Department came into being on the 12th of April 2010. There had been suggestions that the Department had been implementing these arrangements without the Minister's knowledge or at the direction of NIO ministers, and that is wholly incorrect. The Department hasn't been involved in any way in such a scheme, and I think it's important to make that point absolutely clear. A second area where there's been a degree of confusion is whether or not responsibility for this issue devolved in April 2010. The reality is that it was not devolved. It remained a matter that was reserved to the Secretary of State. The Secretary of State at one point appeared to suggest that responsibility for the scheme had devolved subsequently, but she has since clarified publicly and definitively that it was not. In terms of planning and implementing the devolution of justice, there was never any suggestion that this scheme should form part of the DOJ's responsibilities, and it did not. It isn't, of course, unique in that regard. Several policy areas relating to justice and policing have remained reserved or accepted since 2010. National security, aspects of dealing with the past, such as pre-1998 public inquiries, extradition, the parading legislation, and so on. The British government clearly regarded this issue as falling within that group of accepted or reserved matters. A third area where there's been public comment is the fact that the Justice Minister was not briefed about the scheme by NIO ministers, and also that I personally or other DOJ officials did not tell him of the scheme. The Minister wasn't briefed on the scheme because it hadn't been devolved and therefore, as I've said, didn't form any part of the DOJ's responsibilities. That position was, I believe, entirely consistent with the rules and conventions governing disclosure of such information. The particular arrangements for addressing the OTR issue within the NIO remained a matter for the Secretary of State when justice was devolved, and it was and is a matter for the Secretary of State what is made public about those arrangements. In point of fact, I personally did not know that the scheme continued to operate after April 2010. I first became aware of that at the same time as the Minister, with the outcome of the Downey case. The procedural guidance on the Ministerial Code relating to access to the papers of a former minister, approved by the Executive in March 2009, outlines the conventions that govern the disclosure of information in these circumstances, and I believe the committee has a copy of that guidance. They are designed to ensure that ministers are able to consider and discuss policies without fear of their deliberations being made available to their successors, and to protect the confidentiality and impartiality of civil service advice. These conventions operate across the NICS in every department and are a key element of how our system of government with a politically neutral and impartial civil service operates. I understand that equivalent rules operate not only in Whitehall but in Edinburgh and Cardiff also. I have, I believe, acted throughout in accordance with that guidance. The Minister has been briefed comprehensively on every aspect of the DOJ's responsibilities since the first day of devolution. But in this particular instance, the issue had not been transferred and remained the political and operational responsibility of different ministers in a separate administration. Nor, even if it had been appropriate, would I have been able to assist the minister on the detail, since I wasn't involved in the administration of the scheme. I believe that it was proper that officials should not have discussed with the Justice Minister a matter that remained the responsibility of NIO ministers, and I believe the Justice Minister shares that view. Thank you, Chair. I'm, of course, happy to try and help the committee in any way I can.
Thank you, Mr Perry. And there may be some questions that maybe touch on some of the points that you've already raised, and I've endeavoured to highlight some of those points. And you may not be able to answer some of these questions, or you may feel that you don't have to answer them, but I'll ask them anyway, and obviously we'll deal with the response that you will provide to us. Whenever you served in the Northern Ireland office, what position did you hold?
I was Director General Criminal Justice and Policing.
And what responsibility then did you have over the OTR scheme within the Northern Ireland office?
None at all.
Were you aware of the scheme when you were in the Northern Ireland office?
I was aware there was an existence of a process for looking at individual cases along the lines that Drew Harris outlined to the Policing Board in 2010, and I was aware that the outcome of that process was conveyed to individuals by means of a letter, but I have no knowledge of which individuals applied, what letters they received, or what information those letters contained.
Before the devolution of justice, were you aware that the scheme had ended?
I didn't know. I'm sorry, could you ask that question again?
Before the point of devolution, were you aware that the scheme had ended?
I knew the scheme had been in operation. I didn't know that it continued after devolution, as I've said.
It's not quite the question I asked.
Well, I didn't know it had ended, but I didn't know it had continued either.
You didn't. So you knew the scheme was operating
before devolution.
Before devolution.
Yes.
At no point you were aware that the scheme had ended prior to the point of devolution.
I hadn't been aware of it formally ending. No.
No. Okay. So at the point of devolution, acknowledging that you were aware a scheme existed, you were aware that the scheme had not ended. What advice did you take to decide that this wasn't a devolved matter that the minister shouldn't be made aware of?
Well, the decision on what issues would devolve and what wouldn't devolve were taken by direct rule ministers on the basis of legal advice. I wasn't consulted on.
Because you highlight that issues like public inquiries was retained by the direct rule ministers, but am I not correct in saying that that was specifically legislated upon, that the Attorney-General, if there were currently inquests that were being requested were on his desk, that legislation was enacted so that he would explicitly have that power to take decisions on those that were currently with him?
It may well have been, Chair. I don't know the answer to that.
Well, I'm informed that there was legislation to enable that provision so that the inquests could be decided upon for those that were currently in existence for the AG. Were you aware of any legislation put in place that said that this on-the-run administrative scheme would be a reserved matter?
I wasn't aware of any legislation, but it was a decision taken by direct rule ministers, and I'm assuming on the basis of legal advice, and also the fact that, as I understand it, the law officers continued to have some oversight role of it after devolution, the law officers in London, that is. I'm assuming that they agreed with that view.
I'll come back to this point shortly, but what other DOJ officials had knowledge of the administrative scheme whenever they served in the Northern Ireland office?
I don't know.
Would there be more than yourself within the Department of Justice that was aware of the scheme within the NIO that subsequently transferred to the Department of Justice?
I'm not sure who might have been aware of it, Chair. I don't believe anyone who was working on it transferred. But if anyone had been, I'm sure they were carrying out their duties as the direction of ministers as they should have done as civil servants.
You knew of the scheme, you knew the scheme didn't end. Whenever you became Permanent Secretary, what steps of the Department of Justice, what steps did you take to inquire about the scheme, whether it had ended, whether it was continuing to operate, and whether it should have been a matter that your department was now responsible for?
I didn't ask whether it continued. I had no reason to believe it had continued, but it wasn't part of the DOJ's devolved responsibilities, so I didn't ask that question. In terms of asking whether it had been properly remained a reserved or accepted matter, I mean, that was a decision for NIO ministers.
Well, on whose advice did you act in taking the view that this wasn't a Department of Justice responsibility?
Well, legal advisers advising direct rule ministers at the point of devolution clearly took that view.
So there was legal advice sought at the time by NIO that this wasn't something that should be devolved?
I'm assuming that, Chair. I didn't see it.
Okay, but as Permanent Secretary of the Department of Justice, you didn't take legal advice to determine if this was a matter that was now a transferred issue?
No, I didn't.
Are arrests, charges and prosecutions a devolved matter?
They are devolved, but not every aspect, as I said earlier, relating to justice and policing is devolved.
Is an administrative scheme a matter of national security?
I'm not sure what classification direct rule ministers put on it, but that may have been the view they took.
Have you, now that this is obviously in the public domain, what steps have you taken to assure yourself that this isn't a devolved matter, or that it is?
Well, I believe legal advice has been sought, Chair, but I haven't seen the result of that legal advice.
And was that commissioned by the Minister, or did you suggest to the Minister that this is something that you need to bottom out?
Well, I think that's a question you probably need to ask the Minister when you see him.
Why didn't you ask for legal advice at the point of devolution?
Because direct rule ministers, receiving whatever advice they had decided what was going to be devolved and what wasn't.
And you took the word of a direct rule system, which you don't know, sought legal advice on this particular issue, but you make an assumption that it did?
Well, I believe it did, Chair, but I didn't see the advice. But the constitutional arrangement around devolution was that certain matters were reserved or accepted, and I'm assuming the basis on which they were reserved or accepted was sound. And as I've said, the continuing involvement of the law officers in London would suggest that they took the same view.
Did the Minister or his special advisor ever ask about this issue until it became public very recently?
No, but then they wouldn't have known about it.
In terms of the 38 figure, which is put out as the number of people who received these letters at the point of devolution, I think it's 38 that were issued by the current Conservative Liberal Democrat coalition. Is 38 the total figure at the very point of devolution? Because obviously I think the Labour government were still in power for a period of time.
I have no idea how many letters were issued by either administration.
Have you sought to establish that information?
No, I've had no involvement in the scheme either before or after devolution.
Do you not think it's something that you now should be seeking to find out?
Well, I think, as I understand it, until legal advice is clearer, I think this remains a matter for the Secretary of State and the British government.
Have you ever discussed this issue in your role as Permanent Secretary with any of the criminal justice agencies that you're responsible for?
No.
Let me just go through some of them specific. You've never discussed this with the Police Service?
No.
The Public Prosecution Service?
No.
The Policing Board?
No.
What about the English Attorney General, who had the oversight of this?
No. No dealings with him at all. So
you personally, nor the Department of Justice, has ever had any dealings with this issue at all from the point of devolution?
Yes.
Okay. In terms of the first day brief, and I want to touch on the executive paper that talked about access to papers of a former minister. You've taken the view that this was an issue that the minister didn't need to be informed about because, in your opinion, it wasn't a devolved matter. And you took that opinion without seeking any advice on it.
Well, that is the constitutional arrangement as I understood it at the point of devolution.
Because when I look at what the Executive agreed on the 5th of March 2009, it talks about, in paragraph 2, ministers have a legitimate interest in the development of policies which they may inherit on taking up office, and officials will need to reconcile as best they can the need to provide present ministers with all the information they need to do their job, with the convention that's outlined above, which seems to talk more about not revealing a minister's particular opinions or deliberations on the issue as opposed to the facts pertaining to the issue. Whenever you were drawing up the first day brief for the Minister of Justice, did you ever look at the Executive guidance as to what a minister should be informed, or did you from that very point decide this isn't a devolved matter, so therefore I'm not telling the Minister because I don't need to?
Yes, I think the operative word in that sentence, Chair, is inherit. The DOJ did not inherit this scheme or anything to do with it. It remained a reserved matter for the Secretary of State.
Which seems to strike to me as very convenient, with the greatest respect, that at the point of devolution you decided, without taking any advice, that this was not a devolved matter, that this was something that direct rule ministers had taken a view that they would retain, and you're making an assumption that they had sought legal advice at that time. But as Permanent Secretary of the Department, did you not have a new master? And your new master was not just the Minister for Justice, but it was also the Executive, it was also this Assembly, and your duty in the first place was to your new political masters, and therefore should you not have been seeking to advise them about this policy which you were aware of? You knew it hadn't ended, but it would appear to me that you've made a number of assumptions to then justify why you didn't tell anybody about this.
Well, I'm completely responsible to the Justice Minister and the Executive and the Assembly for all the responsibilities that are devolved to the DOJ. But this issue wasn't devolved, as I understand it, and that was a decision that was taken prior to devolution by direct rule ministers who I think had the authority to make that decision.
That you think had the authority to take this decision?
Well, I believe they had.
Based on your own opinion or based on legal advice that you sought at the time?
Well, based on my assumption that they took legal advice on what should devolve and what shouldn't.
Do you not think that's a very dangerous assumption to have made? That something, when you're talking about arrests, prosecutions, charging, all matters that are devolved, unless they're matters of national security and unless they are reserved by Westminster, which you don't know, bar an assumption that you've taken to base a decision not to inform the Minister for Justice, the Executive and this Assembly about?
I think, as I've said, there are a number of areas which are reserved or accepted, which remain the responsibility of the British Government that remains accountable and answerable for those issues, and this was one of them. And as I said, I'm not sure which heading this particular issue fell under as far as they were concerned, but I'm quite clear that it was not devolved.
Yeah, you say you're quite clear, but you're quite clear based on a number of assumptions that you made at the time. You didn't seek legal advice at the point of devolution to satisfy yourself about a scheme that you knew existed, you knew it hadn't ended, but yet you made an assumption that this was a matter to be dealt with by Westminster. Surely you should have been seeking your own independent legal advice to advise you as the Permanent Secretary what information should be passed on to the new Minister and the Executive. But you didn't do that.
Well, I believe the decision about what was devolving and what wasn't was one for direct rule ministers to make, and I have no reason to think that they did not make that based on properly authoritative legal advice.
As the accounting officer for the department, surely you should have known, and if you didn't know, you should have made it your business to know how taxpayers' money was being spent by the police whenever they were administrating this particular scheme, which you knew existed, you knew hadn't ended, but it would appear when you became the Permanent Secretary, it was a case of see no evil, hear no evil, and let's keep the head down because I'm making an assumption that this is a reserved matter and not devolved. Surely you should have made it your business to have found out. Well, and have you not failed in your job?
I don't believe so, Chair. I didn't know, as I said, I didn't know it had continued, but in terms of what the police or the PPS spend their money on, these are operational issues on which it's a matter of operational decision by them.
Yeah. You say you didn't know it continued, but you knew it existed and you knew it hadn't ended. Now, it's a clever play on words to say you didn't know it continued, but you knew it hadn't came to an end at the point of devolution, but yet you didn't, at that point, seek your own advice as to whether or not this actually is a devolved matter, and then, had you have done so, that advice may well have indicated you should advise the Minister, the Executive and the Assembly about this particular issue. I find that remarkable.
Well, I know I'm repeating myself, but the decision on what was devolved and wasn't was a matter for ministers who then had that responsibility. I didn't know it had continued, and it was quite clear the range of issues that was devolving to the DOJ, and for all of those issues, I'm sure the Justice Minister was completely briefed.
What about the prison service? They were involved in this scheme. What information are you aware that the prison service involvement had been? I know there's a reference in Mr Justice Sweeney's judgment to some work that the prison service did before 2002, as I recall it. But I have no further information than that. You're seeking that information, though, or at least I think the Minister has been seeking that information.
Yes, I haven't spoken to the Minister about that. I mean, I think the formal position is that papers for 2010 formally belong to the NIO, and this issue was not devolved. So, in order to pursue that, I imagine the Minister will need the agreement of the NIO, but I haven't had the chance to speak to him about that.
See, what baffles me around the foolhardy assumptions that you made at the time of devolution is illuminated by one of the members of Parliament who asked a question on the Attorney General's response to this, because these questions were put to him that the process continued after devolution, yet it had profound implications for the work of the HET, the Northern Ireland Police Board, and it continued without the knowledge of the Minister of Justice for Northern Ireland or the Police Board. Who administered the scheme, who negotiated with devolved institutions behind the back of the Minister of Justice for Northern Ireland so that this scheme could continue. That was Naomi Long, Member of Parliament for East Belfast. And the response from the Attorney General was, the Honourable Lady raises a large number of highly pertinent questions. Now, if the Attorney General regards those questions as highly pertinent, surely you, as Permanent Secretary of the Department of Justice, should have regarded them as highly pertinent rather than making assumptions which then led to you withholding information to the Minister for Justice, the Executive and this Assembly.
Well, the questions I'm sure are pertinent, but the NIO, for devolved matters, the British Government has direct engagement with a whole range of independent organisations, in terms of Justice Senior, the PPS. This remained a matter for the British Government and not the Department of Justice.
Based on assumptions that you've made, that's the opinion that you have came to? Well, because it certainly isn't on the basis of any independent legal advice that you took at the time, because you didn't take any.
Well, as I say, the constitutional arrangements around the devolution of justice, I've no doubt that the then responsible ministers did take this advice.
You talk about the constitutional arrangements, and yet I point out to you that the likes of inquests was actually deliberately legislated for, to allow the Attorney General to continue to take decisions on issues that were currently with him. This was an issue that was clearly currently with the British Government at the time, which nobody knew about. But I don't see anywhere in legislation at the point of devolution that explicitly stated an administrative scheme providing letters to Republicans will be retained and be a reserved matter for Westminster to deal with. But you making an assumption that because a direct rule minister says this is a matter we're going to keep, therefore it's an issue that you're now going to close your ears to and shut your eyes to without getting any independent legal advice as Permanent Secretary of the Department of Justice. I find that not just remarkable, incredulous that that's the position that you would take.
Well, just to repeat the point, Chair, I do make the assumption, but I think it's a reasonable one, that the division between devolved and non-devolved matters that direct rule ministers took was taken on the basis of authoritative legal advice. It was quite clear the issues that were devolving to the DOJ for which I had responsibility, and those are the ones I briefed the Minister on.
Okay. Have you sought any advice then from the head of the Civil Service to identify if you have carried out your duties within the protocols that would have been expected?
I've discussed the issue with the head of the Civil Service, and I've no doubt if he thinks I've done anything wrong, he'll tell me.
So it's been raised with the head of the Civil Service. Has he given an opinion initially to you about your withholding of this information?
He's aware of the issue. I'm not sure he's given an authoritative view.
I know certainly I've spoken with a number of ministers about this issue, and I know what position they would have taken had you been the Permanent Secretary to them.
Well, I think you've probably heard David Ford's position.
I've heard David Ford's position, yes. You may, if you want to ask some other ministers what their view is. Certainly, if I was the Minister for Justice and you had withheld this information from me, you wouldn't be my Permanent Secretary, because it would be a clear breach of trust, in my view, that you withheld this information based on nothing more than your own assumptions. That's not something that I would tolerate from any Permanent Secretary. So I'm surprised David Ford's tolerating it.
Well, I'm entirely satisfied, Chair, that I've acted entirely in line with the ministerial guidance or the procedural guidance issued by the Executive and the constitutional arrangements surrounding devolution of justice.
I'm certainly not satisfied at this point. I appreciate I've taken up quite a bit of time, so I have a number of other questions, but let me bring in members first of all, and then I can come back to some. Mr McGuinness.
Thank you, Chair, and thank you, Mr Perry, for coming along. Mr Downey was arrested on the 19th of May 2013. Did you have any discussion with the Minister for Justice after his arrest?
No. I wasn't aware he'd been arrested.
You weren't aware that he was arrested?
Well, at least it may have been in the news, but I wasn't aware of it.
Yeah. Well, when did you become aware of the fact that Mr Downey had been arrested and charged and was in possession of a letter from a senior official in the Northern Ireland office dated July 2007, a letter which it was part of the administrative scheme? When did you become aware of that?
When Mr Justice Sweeney's judgment came out.
So you weren't aware during that period of time, from May 2013 right up until the case concluded on the 21st of February 2014?
No.
You're serious about that?
I am, Mr McGuinness. I mean, it may have been in the news, but I certainly didn't pick it up.
I found that quite surprising, given your senior position in the NIO prior to devolution, knowing about these letters of comfort, and yet you didn't put two and two together in relation to Mr Downey.
Well, as I said, I had no involvement in the scheme, and I wasn't paying attention to the case against Mr Downey. So.
Well, can I just ask you then, in relation to, we've received procedural guidance, access to papers of a former minister. You've said this wasn't a devolved matter, therefore, do we assume then that the procedural guidance, access to papers of a former minister, are irrelevant to our discussion today?
Well, I think they're relevant in the general sense of parties belonging to papers belonging to former ministers of a different party, but I think they have a particular force when the issue hasn't been devolved in the first place.
But how can they be relevant at all?
Well,
I mean, if this, sorry, just to clarify the position from where I'm coming from, if you say this was not a devolved matter, does it matter one way or the other the procedural guidance, access to papers of a former minister? Surely it doesn't matter.
Well, I think the general principles probably still apply, but I agree that the guidance doesn't quite capture the situation we're talking about here, where an issue has not
But
been
why
talked
have we been given these papers in relation to procedural guidance?
because they are, as I say, they're broadly relevant in terms of the principle.
Well, I don't understand that, but it seems to me that we've shifted ground here, that you're saying that this is a non-devolved matter. Whenever the Minister was in the Assembly and asked questions about the OTR letters, he was saying, well, look, there is a convention and therefore I didn't know anything about this. But that is not the position. It was a non-devolved matter.
Well,
Is that the preferred position?
well, I'm not. I don't think it's shifting a position. I think it's a combined position, Mr. McGuinness. These conventions would apply even in relation to a non-devolved matter. I think they have particular force.
Well,
that hasn't been
can I deal with then just very quickly the whole essence, the whole thrust of these of the procedural guidance is to prevent embarrassment for a previous minister by the successor minister taking over and saying, haha, he did such and such, blah, blah, and I'm going to embarrass him. To prevent that sort of embarrassment happening, is that correct? We see that in paragraph 2.
That's one of the reasons. There are a number of reasons listed in paragraph 1 too, of course.
Well, in paragraph 2 it says the guiding principles should be to avoid embarrassment to previous ministers and to ensure that disclosure of particular documents to present ministers would not be liable to reveal directly or indirectly the personal opinions of a previous minister of a different political party. So it's to avoid political embarrassment, isn't that right?
And to protect the ability of ministers to consider and discuss policies without fear of the deliberations being made available, and to protect the confidentiality and impartiality of civil service.
Well, the main thrust is to avoid embarrassment. But in actual fact, the opposite is true in this case, because the minister was severely, the current minister, Mr. Ford, was acutely embarrassed in a situation where he had no knowledge of the OTR letters.
Well, the disclosure of information, both the disclosure of information about the OTR scheme rested with the ministers who had political and operational responsibility for it, and those are direct rule ministers.
Well, I mean, it seems to me that the purpose of the procedural guidance, if I could just go back to that, was to avoid embarrassment to a previous minister, but conversely, it was, you could say it was to avoid embarrassment to a current minister. Is that not?
Well,
or is that straining things?
I mean, I think these arrangements are designed around, well, as you've described them, Mr. McGuinness, it is the responsibility of those who have political responsibility for the issue to make public detail about it.
Well, this is a convention. It's not. There's no statutory duty or anything of that nature. In the circumstances, did you not, even given your limited knowledge in relation to the OTR letters, did you not think that, well, maybe this is such an exceptional case, this is a unique situation, maybe I should disclose some information to the Minister in relation to this scheme?
Well, as I said, there's a number of issues which have not been devolved, relating to policing and justice.
But no, I understand that point that you're making, but you had personal knowledge in relation to this scheme. It mightn't have been the complete knowledge that others may have had in relation to this scheme, but you had knowledge of it, surely. You had knowledge of Operation Rapid, surely.
Is Operation Rapid the issue that is after devolution?
Yes. It was February of 2007.
Just before.
In fact, I didn't have knowledge of that. As
You had no knowledge?
I had no involvement in the scheme.
You had no knowledge of Operation Rapid?
No, I didn't.
Thank you, Chair.
Mr. Humphrey.
Thank you very much, and thank you very much for your time today. Can I ask you, Mr. Perry, you are the Permanent Secretary of the Department of Justice now, but your role in the Northern Ireland Office prior to devolution of justice was?
Director General, Criminal Justice and Policing.
Okay. And so, as others have questioned, you then become the head civil servant, senior civil servant in that department, and the accounting officer to the Minister. Was it not naive of you, given your experience in the civil service, both the Imperial Civil Service and subsequently Northern Ireland Civil Service, to believe this issue wouldn't re-emerge, both the Department of Justice that you were now head of in terms of its administrative workings and the Minister to whom you were as principal civil servant?
I don't know about being naive, Mr. Humphrey. As I said, I didn't know the scheme had continued after devolution, but any issue that arose in relation to it is a matter for the ministers who had political responsibility for it, which are the Secretary of State.
Ultimately, ministers are responsible for politics, that's right. But the point I'm making to you is, did you believe that your inaction and lack of trust, if we call it that, has in any way undermined David Ford as Minister for Justice in Northern Ireland?
I don't believe so.
Well, how can you believe that, given the reaction that there has been and the pressure that's been placed on the Minister subsequent to the announcement of this dirty, shoddy, sleeked deal?
Well, the Minister, as he's made clear, had no knowledge of the scheme, and as I've said, I had no knowledge of it continuing after devolution. But responsibility for the operation of the scheme and for information being made public about it rests with the Secretary of State.
Well, also in relation to you're aware that there has been this deal done between the IRA and the government, the national government, and the decision to do that came after a bill was withdrawn in the House of Commons, and the House of Commons, we're told, knew nothing about this. As a senior civil servant in the Northern Ireland Office, did you warn ministers that this was going to subvent the House of Commons and undermine the parliamentary structure within this nation?
Well, as I've said, I had no involvement in the scheme. I think any advice given to NIO ministers before devolution would be a question to ask the Secretary of State.
You were a senior advisor within the Northern Ireland Office to the Secretary of State. I'm asking you.
Well, and as I've said, I had no involvement in the scheme.
As the Permanent Secretary at the Department of Justice, do you believe, in your judgment, that this scheme has breached national security?
I don't have any knowledge of how the scheme operated, so I can't comment on that.
You will find that, I hope you will understand, but I find it difficult to believe that a senior official in the Northern Ireland Office, who subsequently, after devolution, becomes the Permanent Secretary of the Department of Justice, who doesn't tell his minister, this then becomes a matter of public record, and your minister is exposed, placed in an embarrassing position, a matter of public ridicule, nationally and internationally. And do you feel any guilt about that?
As I've said, this issue was not transferred, and therefore any responsibility for any fallout from the scheme falls to the Secretary of State. As for the Justice Minister's position, he's made it quite clear that he had no knowledge of the scheme, and I'm not sure he would agree with the description you've just given about the reaction to his position.
Well, if he's in a cloud cuckoo land, if he doesn't believe in terms of the reaction to his not him personally, because clearly he didn't know, as the First Minister didn't know, but clearly people around him knew, and you were one of those people. Can I ask you, are you aware that of any of these letters that have been sent, and obviously there's no certainty around the number of these letters that have been sent, would you be aware of any of these letters have been sent to any members of this House?
As I've said, I've had no involvement in the scheme. I have no idea who applied to it. I have no idea who got letters. I have no idea what any of those letters may have said.
Okay. Well, prior to your ceasing being involved with the scheme, would you have been aware?
I've never been involved in the scheme.
Okay. Prior to you not being directly responsible under your Northern Ireland Office role after devolution, would you have been aware of any names if you weren't involved in the scheme? Would you have been aware of any names?
No.
Thanks, Chair.
Mr. McGlone.
Yeah, thanks very much, Chair, and thank you, Mr. Perry, for being with us here today. Just, and I've read the procedural guidance, and obviously the procedural guidance, and just to reflect on it, at paragraph 2, ministers have a legitimate interest in the development of policies which they may inherit on taking up office, and officials need to reconcile as best they can. They need to provide ministers with all the information they need to do their job with the convention outlined above. So clearly, and I've picked up on that general theme running through, that's one of, if you like, the legacy role, the sweeping up of hereditary issues or stuff that's the nature of government. That's the way it works. Could you advise just that we'll talk about the transition or the actual mechanics of sweeping up. During that sweeping up period, and I'm not specific to you, did you or anyone else at the department, or indeed acting on the behalf of the department, pick up on this issue?
No.
No? Right. Can I ask then, following on from that, are you aware, or have you since been made aware, of any undertakings of an amnesty, immunity, or implied immunity from prosecution given to any former or serving members of the security forces, any person who has acted as an agent of the security forces or British government intelligence services, or any other member of any other paramilitary organisation?
No, I'm not.
No. And just, Chair, acting back to the procedural guidance then, the access to papers of a former minister, it says, paragraph 1, minister and junior ministers will observe the convention that they and their special advisor should normally ask to see or be shown documents or papers. Since this issue has erupted, has either the minister or the special advisor or anyone acting on behalf of the department sought sight of any papers relating to this issue or any other potential issues that may arise as a consequence of this, in the line of those issues that I've already outlined to you?
No, I'm not aware of that.
Is that, you're not aware of it, or is that a no?
That's a no.
Right, okay, then finally, and thanks, Chair, the Select Committee, and of course there's been a judge appointed to look over this, the Select Westminster Committee, I presume they may seek and will get access to the papers around this.
I assume so. They are NIO papers, I
yes,
assume.
and similarly, the judge who may have oversight excuse me, of the investigation into these matters.
So I'm sure Lady Justice Hallett will get access.
Yes. So that brings me back to the other point. In case there's anything else, would it not be prudent for the Justice Minister to have an overview or an oversight of these matters to ensure that there aren't any other booby traps, for want of a better phrase, lying, political or otherwise, lying in among some papers that may have been shuffled or parted to the one side?
Well, I don't believe. I mean, I believe any relevant information relating to the sorts of issues you're talking about there, Mr. McGlone, belong to the NIO. The DOJ has no such paper.
Sorry, you've said the DOJ has no such brief.
Papers.
Oh, no such papers. No, I appreciate that. I wasn't thinking of the DOJ papers,
sorry,
but I was thinking of those others that, because Mr. Humphreys has quite rightly said, this has put the spotlight on the Minister for Justice. I'm sure a spotlight he could have done without and preferred to have done without, but I'm sure he would be anxious to ensure there aren't any further spotlights to be brought on him about this or other related issues of the ilk that I've already outlined. So, do you not think it would be prudent then to engage in a scoping exercise before any of this material, if it does exist, is revealed, either as a consequence of the Select Committee's investigations or indeed of the judicial proceedings, whatever shape or form they might take?
Well, I imagine any information of the sort you describe, either pre-devolution or related to the OTR scheme or any other kind of arrangement that you've touched on, all of that documentation is, I imagine, in the possession of the British government. So I'm not sure what the Justice Minister could look into, but it's something one might ask him.
Right, okay, so well, obviously I can't ask you to answer on his behalf, but what he can ask, so he has taken no action of any description of that to either request meetings with NIO ministers or NIO officials, or indeed to seek further information from them if there's anything else lurking in the woodwork?
Well, I think he's on the record of saying he's met the Secretary of State and had robust meetings with the Secretary of State. But I think in terms of the detail of that, it might be best to ask him.
Okay, thank you. Thank you, Chair.
Mr. McCartney.
Thank you very much, Chair, and thank you very much for your presentation. And the Chair has already said there's obviously some of these questions you may not be answered, but I feel best that they are asked. In your former role in the Northern Ireland Office, were you involved in the process which led to the transfer of certain powers to the Assembly? Were you part of that sort of?
I was part of the planning around the creation of the Department of Justice.
So you would have been well aware of what was being transferred and what wasn't being transferred, and the basis on which.
Well, I was well aware of what was being transferred.
So you would have known, say, like in terms of public inquiries, that would have been retained by.
Well, I wouldn't have had any detailed knowledge of it since it didn't fall into the area that was being devolved. My focus was on those areas that were definitely being devolved.
So your focus is more on what was being devolved rather than what wasn't?
Yes.
Okay. In terms of coming here today, have you received or sought any briefing from the PSNI as to how they brought this to the attention of the public in the past?
No, I haven't.
And in terms of the policing board?
No, I haven't.
No. But would you be aware that both the policing board and the PSNI do say that this was in the public realm through briefings to the policing board and our public statements?
Well, I'm aware that there's the conversation that Drew Harris had with the board in 2010, and that is now an ongoing discussion, as I understand it, between the PSNI and.
Okay. In terms of the discussions with the British Secretary of State, have you been involved with them on behalf of the department?
No, I've sat in one meeting that the Justice Minister had, but I've had no meetings.
Okay. Do you know the process which has led her to say that in one instance this was a devolved matter and then change her opinion to say it is not now a devolved matter?
I don't know what led her to say that, but she was certainly incorrect.
But would you not have thought that perhaps would have been part of this conversation? Perhaps ask her, why on one day you say this was a devolved matter, particularly when that became nearly the focus of the conversation, and then she changes her mind. Did the minister ask?
I believe he did. I mean, he could speak for himself, but I believe he did. And after that, she clarified the position.
And did the minister relay to you the explanation offered by the British government for their change of mind?
Not in detail. I think she clearly misunderstood the position.
When you say not in detail, what did he tell you?
Well, I think the Justice Minister himself would be best placed to give a definitive account, but it was clearly when challenged about this scheme being devolved, or what she had meant by devolved authorities, the implication that included the Department of Justice, she made clear that it didn't.
And what was the basis on which the Minister challenged it? Were you part of briefing the Minister?
Because he knew that the DOJ had no part.
Did he just decide, I know this, and I'm going to tell Teresa Villiers, this is not my responsibility, and she said, right, David, I accept that. There was no discussion, no examination of papers, it was just a sort of friendly, you're wrong and I'm right, and she changed her mind?
Well, obviously, the Minister sought confirmation that the DOJ had no involvement, and he received that confirmation, and, as I say, when he put that to the Secretary of State... So
you were part of putting that so that the Minister could go and do it?
Yes.
On what basis did you do that?
The DOJ has had no part in this. The DOJ has had no part in this scheme, I know that.
But had you papers? Did you present papers or present evidence, or was it just a verbal?
The Department has no papers on this issue because we've had no part in it, but he had my assurance that we haven't been involved.
Okay. In terms of, we've talked here about the role of civil service, and it's understandable. The transfer of policing and justice powers, I'm not saying unique, but it certainly was different from all the other departments, given that some of the powers remain reserved. Have you ever found yourself in a situation, perhaps, where the Minister's asked the question, that if he goes to answer it, that you may have information which could compromise him to give a misleading position?
No, I haven't.
You've never found yourself.
No,
Could you find yourself in that position?
I don't believe so.
Well, say in terms of the inquiry and the interference in the police ombudsman's office, if some of those issues were matters that were in the offices of the NIO, and the Justice Minister makes a statement saying that there was only one instance of interference, could you or any other official be in a position that know that there was other instances of interference, but would be duty bound not to say because of the code of conduct?
But the Minister would make any such statement only on the basis of what had happened since devolution. Anything before that is a matter for the Secretary of State and for other accountability.
But, I mean, can I refer you to the McCusker inquiry? That crossed over to both eras, because obviously the recruitment of the police ombudsman at that time was prior to devolution. Right. So therefore, that's why I'm asking that question. Given the code of conduct, could there have been a situation that there were people who were in the DOJ, who were previously in the NIO, would be duty bound and legally bound possibly not to divulge information?
I think anything that the Justice Minister said about that issue related to events since April 2010.
No. It went into the recruitment, and there was allegations made that some of the criteria for recruitment were changed. So that was prior to the transfer.
Well, I don't think the Justice Minister, as far as I'm aware, made any comment about what happened before April 2010.
Because he couldn't. That's the point I'm making about the code of conduct. That's the precise point I'm making.
No.
You could find yourself in a position where there's information which you have, but you would be prohibited from telling a minister. So a minister could be put in a position of giving a misleading statement simply because you're not permitted to inform him otherwise.
Well, you mentioned that example, Mr McCartney, but I think when briefing the Minister, we've always tried to frame it in terms of what's happened since April 2010 and not, I mean, he can't comment on issues that happened before that.
But that's, again, you're making the point for me, because if there was something that you did at a particular time, not you individually, but a civil servant finds himself in a position where they have information, but because of the point of transfer, they can't inform the minister, then the minister can be put in a position that he's making comments or making statements that may be misleading, and the person would know that and can't do nothing about it.
Well, I hope he wouldn't, just to continue on that particular point, I hope that we wouldn't put the Minister in a position where he was commenting on matters before he became Justice Minister. So anything he said publicly would be framed in terms of he's only speaking about the time since he took responsibility for an issue.
Okay. In relation to the Chair mentioned a number of people in terms of contact. Has the Department been in contact with the British Attorney General for his reading on the legitimacy of the scheme?
No.
You have had no contact?
No.
Okay, thank you very much.
Mr Anderson.
Thank you, Chair, and thank you, Mr Perry, for coming along this afternoon. Mr Perry, you're telling us Director General of Justice and Policing up to the devolution of Justice 2010.
Yes.
Is that right? You also are telling us all today that you were aware of a scheme up to 2010.
I was aware of the existence of a process, yes.
Process. I think the question I want to ask, when you say you were aware of a process, how much were you aware of?
Well, as I explained earlier, I was, as much as Drew Harris set out to the policing board, with the additional fact that I knew the outcome was conveyed by means of a letter. That was all.
For someone such a senior position as yourself, and you were aware of, you say you were aware, I find it sort of amazing that someone who was aware of such a scheme, bearing in mind of questions that were asked in Parliament to Peter Hain. Were you aware of those questions that were asked to Peter Hain in 2006 or 2007, then around that time, in relation to the embassy from the runs that was withdrawn, and when other questions were asked in relation to was there any other processes in place? Did you know about that, those questions?
Well, I imagine at the time I was aware the questions had been asked, but I wasn't dealing with the issues. So.
You keep telling us that you weren't dealing with the issues. you keep telling us you're not aware of Fry, you're just aware of the scheme, but I would like to know just really how much you were aware of. It's such a national issue in relation to those questions being asked in Parliament. And for someone like yourself, do you not think it would have been best that you would have acquainted yourself as to if someone or Peter Hain gets up in the House and says there is no other procedure, there's nothing else in place, and you are in a senior position up to 2010 at that particular time, did you not feel uncomfortable that those answers were coming in Parliament when you knew that there was something in place?
Well, I just go back to the point. I think the then Secretary of State must stand over whatever answer he gave back then.
Yeah, but I'm not talking about the then Secretary of State and what the answers he gave. I'm talking about you and your position. If you, like many other people, knew about that, if you knew that those questions were being asked in Parliament, did that not make you, as the Director General of Justice and Policing, very uncomfortable that here was Peter Hain saying that there's nothing in place when you, I would say, did know that there was something little that you were aware of it anyway? I don't know what knowledge you had, but you tell us you had very little knowledge, obviously. But you knew that you were aware of something, and yet we had Peter Hain standing up in Parliament saying that there was nothing else, no other procedure in place. Would that not have made you uncomfortable, anyone uncomfortable?
I don't believe so, Mr. Anderson. That there was some kind of arrangement or process going on is one thing. I don't know that any of that. I didn't have sufficient knowledge of the detail to know that anything that Peter Hain said publicly contradicted that. I'm not sure that it did.
I find your replies to these questions, not just by myself but by others, just really very sketchy, Mr. Perry, because I think anyone in your position should, if you knew something and something else was being said that related to something that you knew, I think, do you not think you should have made it your business to try and find and get to the bottom of what was being done, stay in the position you had in that department?
As I say, another part of the department was dealing with this issue, and I have no reason to believe the Secretary of State's answers weren't correct, but I don't know is the answer to that.
Well, your answer to us all today is, well, I knew of it. It's nothing to do with me. I'm washing my hands clean. If it's nothing to do with me, so I get on with what I perceive to be my job. This is maybe someone else's issue. But even with all the high position you had, you were washing your hands of it.
Well, I'm not washing my hands of it, but I think you've just summarised my position very accurately. I'm afraid I can't give you any information I don't have.
Okay, Mr. Perry, thank you. Thank you, Chair.
In terms of Ms. McCorley, had you indicated? Yeah, sorry.
You were, as you said, you were aware that the scheme was in operation when you were in the NIO, but you weren't involved in it.
Yes.
Was it your sense that it was something that it was very, very classified, that top secret sort of, or what was your sense of it? Was it something that people generally knew about?
I don't know that it was generally known. It was information about it, I think, was fairly constrained, but that was often the way in terms of the way issues were handled in the NIO.
So you don't know one way or the other, really?
No.
Okay. And would that be the same for other kind of issues? You wouldn't really know one way or the other?
Yes.
And then the whole discussion then, since this became a big issue, part of it is about who knew what and when, and there's a lot of people saying that, well, politicians generally knew about it because it was an anomaly in the peace process. Would that be your view, that would you have had the sense that politicians probably knew about it?
Well, I couldn't say what particular politicians or particular parties knew about it. Obviously, the OTR issue was out in the public domain, but what people knew about these arrangements or a scheme, I couldn't say.
But would it shock you, or would it be a shock to you to find that nobody knew about it?
I don't think. My understanding is that people aren't saying they didn't know that there was an issue. The particular arrangements seem to have come as a surprise to people, but I'm speculating. I don't know. Okay,
but given this is a Good Friday Agreement issue and just an anomaly coming out of the prisoner release scheme, and that's the context of it. So it wouldn't be any surprise to you then that any politician who was operating at that time would be aware of it.
Well, I say aware of it as an issue, but what detail about any arrangements I couldn't say.
Okay, thank you.
Mr. Humphreys had a supplementary just
Yeah.
on that.
Thank you very much, Chair, for your indulgence. Mr. Perry, earlier when I asked you about national security and the fact that you were aware of the scheme and you then had a new boss who you didn't brief on the scheme, I want to return to that because we're told, I think there are some 138 letters, or we don't know how many. I find it incredible. I want to return to this because I find it incredible, your answer in relation to national security. Amongst those 138, and we don't know who the recipients of those letters were, clearly some of those people, if not all of those people, were terrorists, many of them murderers. And you don't believe that that was an issue of national security?
It may well have been an issue of national security, and that may be the reason that it wasn't involved.
And we're speaking to you today with respect, sir, because it was devolved.
Well,
And the point I'm making to you is that when it was devolved, it was an issue. It remained an issue of national security. At that point, you didn't feel it was such an issue of national security that you should brief your new boss, the Justice Minister for Northern Ireland.
well, the OTR scheme wasn't involved, and national security isn't involved.
Go back to the point. National security is breached if letters that may well amount to being amnesties are sent to some 138 people, some of whom were terrorists and involved murder. Yes?
Well, as I say, I don't know who got letters, and I don't know what those letters said, so I can't really.
Okay. Well then, okay. Since you're not going to be specific, let me try and be a bit more specific in my questioning. If a certain terrorist receives a letter and he's been involved in murder, he may even have been involved in targeting a government minister, a senior policeman, a judge, whatever. That is an issue of national security. Yes?
It may well be.
Are you suggesting it is or isn't? Are you suggesting for a moment the targeting of a government minister, a judge, or a senior policeman would not be an issue of national security?
Well, I'm sure it would be a matter of national security. But I'm sorry. Yes, so you were saying.
So the point I'm making is, devolution happens, and you still don't believe, even though these people may well have been involved in such nefarious activities, you did not believe it was important to brief your new boss, the Justice Minister for Northern Ireland.
Operation of this particular scheme, as I've explained, wasn't devolved. It didn't form part of the Department of Justice's responsibilities. Anything in relation to that, the operation of that scheme or information being made public about it, remained the responsibility of the British government.
I have to say, I believe your answers to this committee today have been wholly inadequate, and I think the people of Northern Ireland will also. And can I finally ask you, in terms of Secretaries of State that you would have briefed to go in to make statements or answer questions in the House of Commons when you were aware of the scheme and were Director General of the NIO before you came to the Department of Justice, was there ever a time when a Secretary of State was asked a question by the Shadow or by any member of the House of Commons, a question that the Secretary of State misled the House and did not tell the truth?
I'm not aware of that. You would need to ask the Secretary of State.
With respect, the reason I'm asking you is because whenever a minister goes to the dispatch box, he will be briefed by his senior officials and his advisers. You would have been one of those senior officials briefing the Secretary of State for Northern Ireland, Secretaries of State for Northern Ireland. Were you ever aware of a Secretary of State misleading the House of Commons?
Detail of what the Secretary of State were briefed on is a matter for the Secretary of State. As I've said, I had no involvement in this scheme. So to answer that question, I've never briefed the Secretary of State on the operation of this scheme.
Yeah, I didn't say you briefed. I asked, were you aware?
You'd have to ask that question of the Secretary of State.
You're not answering that question?
No, I'm just not in a position to answer it. I'm not aware.
Mr. McGlone had a follow-up.
Please, thanks very much, Chair. Mr. Perry, just to bring you back there, I'm looking at the procedural guidance, the access to papers of a former minister, and it says ministers and junior ministers will observe the convention that they and their special advisers should not normally ask to see or be shown documents or papers prepared by NI departments for directorial minister, etc. At any point, did either you or anyone else within the department suggest to the minister or anyone acting on behalf of the minister that it would be prudent to be shown papers relating to the OTR scheme?
No, because the department possesses no papers related to the...
Sorry, I'm not asking you did they possess them. This guidance here, and you know fine well, this applies to the transition between directorial and I don't have to go over it. You know where I'm coming from here. Did you ask at any point in time, or suggest at any point in time, or anyone acting on your behalf suggest at any point in time that these papers should be shown to the Minister or anyone acting on his behalf?
No.
No. That's okay. Now, secondly, I want to take you into a theme that Mr McCartney was exploring there, about a situation where potentially a minister could be about to make a statement and a senior civil servant withheld information from him or her from their previous department, and as a consequence of that, a minister made a misleading statement. Are we not into disciplinary territory then, where a person withheld the completeness of their experience and knowledge to serve, because they're not serving two masters at this point in time, they're serving one master, i.e. the minister at this point in time. So if that person deliberately, in the full knowledge that this would have ramifications potentially either policy-wise or politically to what the minister was about to say, if that person deliberately and willfully, in that sure knowledge, withheld that information, which led to a situation extremely embarrassing potentially for the minister, or having significant policy implications further down the line, does that not then become a serious disciplinary matter to be handled by the head of the civil service?
Well, if an official deliberately allowed the minister to make a misleading statement about an issue for which he hadn't had political responsibility, then I think that would be an issue.
Right. Okay. Thanks for that, Chair.
Okay, just a couple of points I want some more clarity around. The Public Prosecution Service indicated that they didn't want to deal with this issue through the Northern Ireland office, and that's why the Attorney General had oversight of it. Have you any view as to why the PPS wouldn't work with the office which you maintain retained the power to handle this particular issue, but the PPS wouldn't work with them and they wanted to work directly with the oversight of the English Attorney General?
I don't when we need to ask that question of them, but I think there may be a convention that the Director of Public Prosecution work direct to the law officers, but I don't know. You would need to ask them.
I'll just let the...
The Principal Deputy Speaker will review the Chair in 5 minutes, and the first item of business will be question time.
Right. We're not quite saved by the bell. In terms of the legal advice which is now being sought, I had asked this question earlier this month and the Minister came back and indicated he's waiting on legal advice on a range of issues. Are you able to tell us what the range of issues are that he's sought legal advice upon?
I'm afraid I'm not.
Did the Minister consult with you about the legal advice which he's now seeking?
No.
Do you not find that peculiar that he didn't ask the Permanent Secretary's opinion about legal advice around...
No, I think under the circumstances it's quite appropriate.
So has the Minister deliberately kept you out of the loop on this issue because of your previous involvement?
Well, you would need to ask him that question, but I think it's entirely appropriate for the Minister to seek legal advice directly.
Would it be normal protocol that a Minister would commission legal advice without the Permanent Secretary's involvement?
It would be entirely possible.
In your experience to date within the Department, has David Ford typically sought legal advice without seeking your view on it?
Yeah, on a number of occasions, yes.
He has?
Yes.
Would you have cleared the paper that was presented to the Minister to do with the request for legal advice?
No.
So the paper, how then did the Minister commission the legal advice?
Well,
my experience usually of a submission to a Minister is it'll be cleared by the Permanent Secretary before it gets to the Minister's desk. So if you've been kept out of this request for legal advice, what's the process that's been followed?
I mean, the Department has its own legal advisors. There are other sources of legal advice, but the Minister can go direct to them. In the DOJ, not everything does go through the Permanent Secretary.
I take it the Department of Justice are paying for the legal advice that the Minister has requested?
I'm sure we are.
But you don't know exactly the process that's being followed by David Ford in his request?
Well, you're probably best to ask the Minister that himself, but he's sought legal advice. There's nothing unusual in that.
Do you know who he has sought the legal advice from?
I don't.
Who would the Minister usually seek legal advice from?
The department has its own legal advisors, or from DSO.
Is it the departmental solicitor's office, or is it these? Who are the? Whenever you say they've got their own legal advisors,
Well, it's usually
DSO.
the DSO provides support to the department.
Do you know, has the Minister sought the view of the Northern Ireland Attorney General about whether this is or is not a devolved matter?
I don't know if he has, although I think there's a convention about not commenting on that, even if I did know.
See, in terms of on the runs of any criminal activity, because obviously you can be charged and people abscond and they go on the run for whatever the crime is. Who deals with people that go on the run from criminal activity in Northern Ireland?
The police.
And is that a devolved matter?
Generally, yes.
So, if anyone goes on the run in Northern Ireland today, the police will deal with it because it's a devolved matter. That's your understanding of the law. And if they're prosecuted, they'll be prosecuted by the Public Prosecution Service.
Yes.
Is the PPS a devolved matter?
Yes, but in both instances, both the police and the PPS deal with some matters that are reserved and accepted.
Yeah, no, and I covered that point earlier, that I think there's a huge question mark about this not having any legal foundation for being withheld whenever the point of devolution took place. You confirmed earlier that the Minister hasn't asked for any papers around this issue from the Northern Ireland office. He's had a conversation with the Secretary of State, but to your knowledge, he has made no request for access to papers.
Well, not so far as I'm aware. But again, it's a question you could ask him.
Yeah. He kindly has agreed to come to the committee, so we will. Mm-hmm. In terms of the legal advice that's now being sought, do you think it's necessary to seek legal advice as to whether or not this is a devolved matter?
Well, I think it's certainly entitled to seek legal advice.
Yeah, no, obviously the Minister's entitled to that, but as Permanent Secretary of the Department of Justice, do you believe there is a question mark around who is now responsible for dealing with this issue? Or are you absolutely certain this is not a devolved matter?
No, I think it's entirely proper to seek that advice. Now, this has become a public issue. What I am clear of is that the point of devolution, the judgment was that this was not a devolved matter.
Yeah. I just want to home on that particular question. Do you believe there is a question mark around who is legally competent to deal with on the runs?
I'm not going to prejudge whatever legal advice has now been sought.
Do you believe there is a question mark as to who is legally competent to deal with this issue around on the runs?
I believe a question has been raised and legal advice has been sought.
Do you believe it is necessary to seek that advice?
I'm sure it's appropriate to seek it.
But you didn't think it was appropriate at the point of devolution to seek it, so why now, some 4 years later, do you think it's appropriate that we would seek advice to determine who is legally competent to deal with this issue?
Because it is an issue now of public debate, and but I am absolutely clear, as I've said before, that at the point of devolution, the view was taken that this was not a devolved matter.
So if this had never been raised publicly, and there wasn't any debate around this, as Permanent Secretary, you don't believe it would be necessary to get the legal clarity around whether this is a devolved matter or not?
At the point of devolution, the clear view was that this was a reserved or accepted matter. That the legal advice that is now being sought may go further light on it. It may confirm that opinion.
Yeah, but you've said that you feel it is now, given the public interest, appropriate to seek legal advice. Surely Permanent Secretaries don't always jump to the tune of public opinion or matters of public interest to determine what they should be doing by way of the role of the department on an issue. So I'm struck that you think it's appropriate now, but at the point of devolution, you clearly made assumptions and didn't feel it was necessary to seek the advice which you now believe is appropriate.
Well, I think it's appropriate to seek advice because it's now become a matter of public debate. At the point of devolution, the clear view of the ministers responsible at the time was that this wasn't an issue that should be devolved.
Well, in seeking the advice, will you be wanting to seek advice to determine whether or not the letters that were issued after the point at which devolution occurred had any legal authority for the NIO to be involved in that?
Well, I'm assuming that that is the area the legal advice will already sort.
But do you think advice should be sought to determine if those letters issued after devolution were issued illegally because the Northern Ireland office didn't have the legal competence to be dealing with it?
Well, I imagine that is the area, one of the areas that the legal advice will cover, or Lady Justice Hallett's review will cover.
We'll wind this up soon. Mr. Humphrey, if we can be brief.
Okay. I think the line of questioning we've just had actually makes the point that I made earlier on, that this issue was always going to re-emerge, and you have clearly said this is now a matter of public debate. And I think, a blind man and a galloping horse, quite frankly, would have realised this was going to re-emerge and become a matter of public debate. And I think that's why you should have briefed your minister at the time, but you failed to do that. Can I ask you, what is the relationship between yourself and the Minister of Justice for Northern Ireland?
In personal terms?
In professional terms, following the announcement of the On the Run scheme, which you had knowledge and he didn't, and you didn't tell him?
Well, entirely constructive, as it has always been. But that's a question perhaps you'd best put to him when you see him next week, whenever it is.
Yeah, and I will, but I'm asking you now.
Yes, well, no, the relationship is fine.
Okay, so it's entirely normal and appropriate, and the way a department would run, that he seeks legal advice without your input. And I think we said more than one occasion he's done that. And also he has asked for papers, and you think that it's appropriate that he asks for those. But again, you have no input into that either. You see, having listened to the evidence you've given here today, I would suggest that the department is, in terms of the minister, who is the political head of the department, and you, sir, as the administrative head of the department, that department is actually today dysfunctional.
Well, I don't agree with that description.
I would suggest if the minister is going and getting legal opinion without your say-so or knowledge, and he's asking for papers without your say-so or knowledge, it suggests to me there's a clear breach of trust and that it is dysfunctional. Thanks, Chair.
I'll bring in Mr. McGlone and then Mr. Elliott,
sorry,
and then we'll conclude.
Right. Could I ask Mr. Perry, just that I'm listening very carefully to your line of answer. Have you sought legal advice yourself about your role in this matter?
Yes.
And was that legal advice sought in advance of you appearing before this committee, in preparation for this committee?
Yes.
Okay. Thanks, Chair.
Why did you feel it was necessary to get legal advice?
Just to confirm my understanding that the way I had dealt with these matters was appropriate, and it has reinforced my impression of it.
The legal advice you've sought has said that you have conducted yourself appropriately in this.
Right. Just one brief. Did you seek that personally yourself, or is that through departmental?
Well, it's on behalf of the Permanent Secretary through government lawyers. Yeah.
So, right. Okay. Thank you.
Mr. Elliott.
Chair, thank you, and apologies for being late. Thanks for coming. Mr. Perry, I have just one question. If it has been answered, apologies for that. It's in relation to the procedural guidance and the access to papers of former ministers.
Yes.
Is that relevant to you being having access to the papers of the former ministers of the UK government or the NIO? Because this procedural guidance was brought in by the Northern Ireland Executive,
yes.
And I'm just wondering what the relationship is with that and the NIO or
The same principles apply to right across the United Kingdom, as I was saying earlier. So essentially the same guidance applies in Whitehall and Edinburgh and Cardiff, and it certainly, the principles relate to both devolved departments and changes between them, and also between a devolved department and a non-devolved department.
So this strictly relates to any minister in any government within the United Kingdom?
The same broad rules do apply, yes.
Even though this is a Northern Ireland executive procedure?
Yes, I mean this is specific to Northern Ireland, obviously, and is approved by the executive, but very similar rules apply across the civil service throughout the UK.
Yeah, it may apply, but there's nothing to say that this particular guidance applies to you in the former department of the UK government?
I think the same basic rules would apply. Do you mean when previously serving in another department?
Yeah.
The same rule?
We're previously serving in another department within the UK government as opposed to Northern Ireland executive?
Well, the same basic rules would apply.
Has legal advice been sought on that particular issue?
On the procedural guidance?
Yes.
Its application in this case?
Yeah.
I'm not sure, even at a sort of general level. My understanding is that it does apply. And
what do you base that on, sorry?
On the legal advice that I've received myself about the steps I took.
Okay. Thank you, Chair.
Mr. McCartney.
A couple of brief questions. Is this your first role as a Permanent Secretary?
Yes.
You have said here that David Ford, the Minister, has sought legal advice without your knowledge in other issues?
Well, I know he sought legal advice, but I've not been directly involved in it.
Okay. And that's thank you.
In seeking your own legal advice, did that include whether or not you should appear in front of this committee?
No.
Did you ever give consideration as to whether or not the judge-led inquiry should come first and this session should be put off until that process had been concluded?
No, my accountability is to this committee.
Would you expect the Director of the Public Prosecution Service to take the same approach that you've taken?
That would be a matter for him.
Do you think it's an appropriate line of defence for anyone to use that there's a judge-led inquiry and that should take precedent before appearing in front of this committee?
I'll be able to comment on that, Chair.
Finally, is there any questions that we haven't asked?
Any questions have you answered?
That we should ask to solicit any information that needs to be put into the public domain that relates to this issue?
I don't believe so, Chair. It's been very comprehensive. The point is, many of the questions that have been raised today are matters for the Secretary of State.
Well, I think if we can determine who actually is legally competent to be dealing with this issue today, and hopefully the legal opinion being sought by the Minister, which I find very strange that you're not party to and haven't been included upon. I think that's highly irregular for a Minister, certainly my experience of having worked with Ministers, to ever seek advice of that nature without the Permanent Secretary being involved is highly unusual. But that's a question that we'll certainly want to put to the Justice Minister whenever he appears before us. And we've asked a number of questions, and I think there are more questions now arising from the answers that you have provided, but I would rather go through a transcript of what's just taken place and determine if there's any more questions to follow up. If there is, would you be prepared to come back to this committee if that's necessary?
Of course.
Okay, well, Mr. Perry, can I thank you for coming to the committee today and taking up of your time? Thank you.
Thanks, Chair.
Okay, members, any other business? Okay.